mind muting so that we don't hear a lot of extra noise. If you have questions, you'll have to unmute, or you can. I will monitor the chat. So if you have questions, I'll try and MC the questions through the chat system. So we've got 19 people. I think if we all start to talk at once, it's going to be a bit of a mess. So Adam, why don't you take it away?
Hi, everybody. So I'm Adam Rosenberg, and I own a small business called Acme Patent Drawings. I have a team of 3 people, aside from myself, that I've trained from the ground up to create patent drawings to comply with the U.S. Patent and Trademark Office's guidelines, as well as WIPO and other countries and foreign offices. I became an expert at this through 15 years of doing it and making all of the mistakes and learning from it. So I was talking earlier before the meeting started, there is no school or certificate program or any type of curriculum that teaches you how to do patent drawings, but it is an old trade that dates back to the first patent. There's a guide called the MPEP guide, which I believe, Mike, correct me if I'm wrong, hasn't been updated since the 50s, at least in the drawings department. So we have some draconian laws or guidelines on how to do drawings, and when things change, it's up to the examiners, and sometimes we don't know that. But specifically, I'm here to talk about design patents from a patent illustrator's viewpoint, not from an attorney's view. And I've been able to learn how to create a claim strategy. And specifically for you inventors, design patents are easier to get. They afford you a lot of protection that the utility patents won't. Utility patents are much more trickier to get and expensive. So this is a great way to, protect your invention in another way. So I'm going to go through this presentation that I have here, and at the end of each slide, feel free to chime in if you have any questions, or submit them through the chat, and Doug can ask them out loud if you don't feel like talking, which I completely understand. And we'll go from here. So first thing I want to teach you guys is that the difference between a design patent and a utility patent. So it is, in general terms, a utility patent protects the way an invention used and works, and a design patent protects the way it appears. So the ornamental design, anything that's on a surface, say you have a t-shirt and you want to protect what the design on that, you can actually do that. You can do that with a trademark as well or whatnot. But maybe you have a backpack like that's shown here that you want to protect because there's a specific mole design on the front of it. So right off the bat, this is what a utility patent drawing would look like. And I'm sure you've all seen them. They have these numerals that refer back to your specification that is typically written by your patent attorney, such as Mike. And it's a visual representation of what's going on and how it works. Then we have a design patent, and we'll go to this backpack here. That this is a published patent that was created for a company called Camelback. I'm sure you've all heard of them, or maybe even have their bottles, but they also make backpacks. This is a really advanced design patent. You'll notice there are different types of lines. There are dashed, solid. There are heartbeat break lines. There's different brackets here, and all of these symbols, indicate something. So to go through this one, just to quickly review, anything in dashed lines is telling the examiner that this is not necessarily a part of the design, rather puts it into context. So there may or may not be stitching there, but we want to draw it in there to make it look like that. This break line here signifies that these straps could be any length. And instead of making, one that is really long, we're going to just break it up onto that little point and symbolically tell the examiners that, hey, it could be any length. As we go on, you'll notice this is called a top, front, right side isometric view. A typical design patent includes 7 views, 1 perspective or isometric, and then 6 orthogonal views, which is front, rear, left, right, top, bottom. There are always exceptions that you can exclude certain views, especially if the bottom of your product is not ever seen or used. You can exclude it oftentimes. But in this one, here's the front view. The most important part about design patents is that all of the features must reconcile across all views. So all of the measurements have to be done properly. And I'm just going to scroll through this real quick before we go into the nuts and bolts of things. So you can kind of get an idea of what a larger design patent looks like. This surface shading indicates that it's a surface. Sometimes, you know, at least in the US, we require surface shading. In China, they do not. In fact, would kick it back and say, this is not allowed. You have to remove all surface shading. So every country has its different rules and regulations on their patent drawings. And the only way to learn them is to go to their patent offices and read well. So let's go through that. So you can kind of see now we did it in an iterative fashion so that we have, you know, this bag has a lot of functionality. You know, we can connect this back straps to it, or we cannot. And so we did it whole in the first embodiment. Then we just did the bag. Then we did the bag in a different configuration, showing it open. Okay. Now, the tricky thing about this one was it's a soft good, meaning that it can take any shape or form. You shove something in it, the bag deforms. Not many people can create 3D models of soft goods, but there are some industrial designers that do. And me as a service provider, that's we do that. And I do believe it is 100% absolutely necessary to have a 3D CAD model of your invention in order to get a design patent properly without getting objection to. It's key. So that's that. So let me just close those 2 examples out. So the value of design patent, you know, many products derive significant value from their visual appearance that you can protect with a design patent instead of doing it with a utility patent. An example, my favorite is a Listerine bottle. When I say Listerine bottle, I bet each and every one of you can imagine the shape of it, the boxiness and whatnot. Now, you don't necessarily need to know the font of the name of the Listerine, but if you just saw the bottle, you would recognize it. That brand recognition of the shape of that bottle is very important. Say a Target has a generic brand of mouthwash, and what they will do is try and copy the Listerine bottle so that they can visually get the customers to say, oh, that looks exactly like Listerine, but it's $5 less. I'm going to go do that. Now, if that bottle is too close of design and Listerine was able to get a patent on that bottle, Target sells 3 million units at $5. Well, you've got a lot of money, and then they can be afforded damages if they sued, which is a process, but that process would net a lot of money for people infringing upon your design patent. The other one is Apple. Apple is the king of patents, in my opinion, right now. They were able to secure the wedge shape for a laptop, which is kind of unbelievable because almost every laptop ever produced is a wedge shape. But now many different computer manufacturers like MSI, which is one of my favorites, stays away from a wedge shape, and they make it more of a box. But if Apple decides, I don't like the way that laptop looks because it's functioning really well and it looks like a wedge, they can sue, or at least send a cease and desist letter and start litigation process and somehow get some money. And that's what it's all about. But yeah, on May 24th, 2018, a jury did award them over $500 million from Samsung's violation of their design patents. So that'll tell you how important these are comparatively to the utility. You know, Samsung and Apple have same functionalities in their phones, but yet they were doing it on the design patent end. That's where it was able to be won. They're typically less expensive and faster to secure than a utility patent. The term is limited to 15 years from the date of issuance. So it could be 2 years from that compared to the 20 from filing date for utility. And it's only limited to the appearance of an invention. So whatever the function is of your invention, especially you mechanical engineers and electrical engineers, you might want to think about how your inventions are housed, just like a car. You know, we can do design patents, and I have done for many different automobiles, but nothing on the inside of it really matters. But if another company creates a car that looks like that car, even if the technology is different, they can sue them and get damages. Design patents can protect competitors from creating anything that is substantially similar to. I wish I could share with you what I'm currently working on, but I'm making exhibits for a litigation right now that a patent was infringed upon. I'll tell you one that I was able to do this past year was one slide company, an amusement park company in Canada, created a tube slide that for everybody to have fun. And then another company said, that looks like ours. We're suing you. You need to take them out of all of your amusement parks, which would have been millions and millions of dollars and could have put that company in a world of pain. And they based it on a design patent that they had. So I reviewed the design patent and reverse engineered it using SolidWorks or 3D CAD and created a model based off of what those drawings were, and found out that that design patent wasn't illustrated correctly. And then the judge, and during litigation it did go to trial, agreed with me with the exhibits, and then that company went free. The other company didn't have to pay a bunch of money, and there we go. So it's also important to get them done properly, because a lot of the examiners, they really don't know as much as the attorneys or the draftsmen. That's just the way it is. Let me see. So any questions thus far? All right. So how do you secure a design patent? Well,
so I got a question for you. What are you using for software for your drawing?
Okay, so this industry standard software for illustrations is Adobe Creative Cloud or Adobe Creative Suite, whatever you want to call it, but we use Adobe Illustrator. It is vector-based graphics, which means we can zoom into this and it'll stay quality, but you can see the background is pixelated. That background is raster, like an image or a JPEG, but the text is in vector, which gives it unlimited resolution. No different than you're making a vector on a calculator, you know, it's the same thing. So the drawing software actually creates, while I'm using my hand or a mouse to create the drawings, it's turning it into math in the background. So we don't have to worry about pixels, and we don't have to worry about quality loss. For 3D solid CAD modeling, you know, pick your poison. There's AutoCAD Inventor as well as SolidWorks, which we use SolidWorks. It is an expensive piece of software. So if you are in school currently and you can get your hands on it to use it, please do so. That is going to really help you out, especially as an engineer. And again, you can come to a service provider like myself as a patent draftsman, or you can teach yourself, or an industrial designer or product designer can use these products. But the most important thing is for design patent is that you get your design completed first. All right. Forget about the functionality. This is form over function, which is probably the opposite of what most of you inventors think about. So when we concentrate on the form of it, then the innards can be whatever. And a design patent is only focused on how it looks and appears. what I do is we'll create the model or have a model. We'll export the views in vector format. I will bring them into Adobe Illustrator, clean them up. There are tangent lines or CAD lines or whatever you want to call them that you can select a couple here and there, use them as a basis for shading, and then go from there. But the most important thing is that all the features reconcile across all the views with 100% accuracy. The examiner will line up all of the views and measure with a ruler and make sure that they're the same height and width. And if they are off, they will get kicked back with an objection. And it's much harder to change things after they're objected to than it is to get it done right the first time. So going on from here, strategies for your creative products and designs. You know, the key to utilizing design patents does reside in the lines used to depict whatever the invention is. I use 3 different types of lines. We have solid, we have dashed, and we have dot dashed. All right, and let me see if I can show you an example here. So here's a solid line. These are claimed. Now, since this is a soft edge, we use shading, contour, light contour shading to direct the examiner to say, okay, I understand the shapes and contours of this. And I also understand that, hey, look, this makes a solid edge at this angle, but it does taper off into this. All right. And we have the multiple views. So this is the front and the rear, and then the left and right. And this right here is actually for a piece of a water bottle. All right. Now here's the disclaimed lines. These dashed lines mean that they form no part of the claimed design. So this could be there or could not be there. So basically, Camelback, you know, if you've ever used their products, they have a bite valve to get the water. So instead of claiming that because they might change it or do something else, we put that in dashed lines, you know. Same thing as the openings on the inside there. These are all published patents. The numbers are up here. Doug will put them up on the website for you guys to use and look at. All right, here is the full bottle. So that was the tip, just the tip up here. And this is the whole top part. And now we have the whole vessel in one patent. All right, so we have this isometric view of front and side, rear and side, top and bottom. Now the bottom, you know, just like my water bottle here has kind of an indentation. We call this the punt of a bottle, and they could be any shape, but that's typically that for manufacturing purposes is, you know, it could change. So to protect, you know, to say, okay, well, I've got this bottle, I don't have a manufacturer yet, so I better not commit to whatever the bottom piece of that is. We put it in dashed lines to disclaim it. So these are techniques. These are another embodiment.
Andrew, just a quick question. So when you say to disclaim it, are you suggesting that this is a preferred embodiment, but not a necessary embodiment? Is that what you mean?
No, when I say disclaim, anything in this image, in this drawing that is of solid line, dark solid line, means that it is part of the design. All right. If you remove these thin shade lines, that's fine. It would still fly. And in fact, that's what you need to do to file in China. But this dash line, this evenly spaced dash line is informing us that there is something there, maybe a cut, maybe a opening, a hole, but we're not claiming that we invented it. We're claiming that it's just there and we invented the design of everything else. That's what I mean by disclaim. So if there was already a bottle with this handle out there in the zeitgeist, then, you know, we could disclaim it, turn it all into dashed lines, and just narrowly claim this part and exclude that. And I'll show you examples of that too as we go on. So when I say embodiments, yes, there are preferred embodiments, but this one, this particular bottle came in different sizes. You had a 16 ounce, a 32 ounce, and a 64 ounce. So Camelback wanted to put them all in one application. And, so this is what we did. We put 2 of them in there. This one is shorter and stout. And then they wanted to claim just the lid so that the vessel itself, might not. And then they can separate these out. And this is Mike's area of specialties, how to, separate out different patents in there and decide which one's which, that they want to pursue. Again, these disclaimed lines. So of course, all of this actually exists on the product, but we're letting the examiner and the patent office know that we are not claiming that we invented this, nor is it a part of the visual or ornamental design of this, but it could be functional. So that's why we put it in dash lines. Same as the opening there. So there's a whole different language, visual language, when it comes to patent drawings than the specifications of a utility patent. If this is a bit too dry, just let me know. All right, so let me go on further. So how to broaden your claim. We were just talking about this. So a common strategy in design patents is to claim the bare minimum possible, like the Apple Wedge. You can imagine a laptop with all its different ports and all the different USB, HDMI, Thunderbolt, all the keys. We put all of that in dash lines, and what do we have left? Just the shape that's basically a square or a rectangle or a wedge. And if you can get that through the office, that offers you a more broad claim, which means you could change the shape and design of the keyboards, the ports, this, that, and still have protection. So over the years, maybe you want to keep the same overall shape of your laptop, but you want to change the layout of the keys, where the mouse pad is, how big the monitor is, etc. If it's all disclaimed and the examiner issued you the patent, then you're in a good place, which is why Apple won $500 million.
And is there an opportunity to design with color?
In Brazil, they allow you to do that. You can file in color, and yes, you can file exceptions if for color. The MPEP guide has an old palette, I would call it, or a color key that has different patterns. Say, for instance, if I filled this bag right here, or even this, with cross-hatching lines, evenly spaced diagonal lines, that would indicate that it's made of a certain color, or it's made of a certain material. That's really specific, and you would have to have a reason, but that would narrow the claim rather than broaden it. And maybe there's a claim strategy that why the attorney would want to do that. Maybe it's because the design is already protected, but you're trying to differentiate yourself from the protected design by making it a certain color, certain material, and saying, I invented it this way, and this is the way mine's always going to look, and it is very different from the one that's already patented. That could be a potential use of that, for sure. Let me see here. Now, there's a lot of text here, so I'm just going to read this. I think this is the most important part, is how do you fight overseas knockoffs, which all of us have bought, whether we know it or not. But it is relatively new for inventors to use design patents instead of utility patents to protect. And what happens is, for example, Doug, you mentioned Amazon. So Amazon has a feature on the website that you can directly submit your claim to them and say, hey, I have the IP rights to this particular design, and you've been selling all of these units over here, and that infringes. So they've built it into their model because they got so many lawsuits. So now Amazon actually is like, okay, we'll do it ourselves. We have in-house attorneys to review this, and we'll decide whether we're going to pull it off the shelf or not, which is great. You can also contact or initiate a United States International Trade Commission investigation, which is that gets really brutal. But it definitely would stop anybody from infringing their products. And it only takes about 16 months to get an exclusion order. And it's effective against copycats who are named and who aren't, people who might even not be. And it's enforced by US Customs and Border Patrol. You have large shipments coming from China of manufactured goods, and they'll review it if they have a tip off of it and take it all or send it back, which is great. And you can also sue for damages, which is what Apple did to win that big case. I will highly recommend, from everything that I've experienced in the 15 to 17 years I've been doing this, don't manufacture your product outside of your home country if you don't want it to be knocked off, because they don't have to abide by the rules of the United States unless they are enforced, which it's really difficult to get China to do what you want when you're an American. And same vice versa. Chinese are not going to get Americans to do what we want. And it's been in the news about how they steal our international intellectual property rights and whatnot all the time, and all over the world. It's not just China. They're just a very easy target for me to talk about right now, because I'm constantly filing patents in China at the same time as the US. So you'll send your model or manufacture your good over there, and they'll keep the molds and they'll wait until you sell, and then they can just hit play again on their CNC machine and produce your product and sell it under a different name, maybe make some slight changes, make a few million units, sell them, and be out of the game before you even know it. So the other thing is, if you have the ability, file your design patent in as many countries as possible that you think you're going to sell it at, or that you think could knock it off. That is definitely my advice on that. So tell me if you guys have any questions. This was a lot shorter than I thought I was going to talk about, but I can pull up all sorts of examples and, talk to me about what you have.
Oh, can you tell us a little bit more about the costs and length of time for the design patents? Are they easier to get, and do they last for a little bit longer?
They back here, they last, if you know, for about 15 years from the date of issuance. Okay, compared to your 20 years of a utility patent. But again, like if you have a car that you've designed and protected, but you change the innards all the time, then that's all protected still by the design patent, which is kind of interesting. It's easy to file. Most of the work for design patents is done by the illustrators or the draftsmen. Everything is heavily relied upon the drawings instead of the specification. The specification is very short for a design patent. It simply goes, this is a front view of such and such, this is a left view, this is a top view, just describing the drawings. It doesn't have call outs and numerals explaining the functionality of it. So Mike, please correct me if I'm wrong, the specification could be 1 page for this. Yeah, that's simple. But the drawing costs will be the bulk of it for a design patent. For the utility, it's going to be the other way around. The bulk of the costs are going to go towards the attorney, because they have to use a lot of the brain power to type all out the specification and do a patent search and whatnot.
So I got a question about the micro entity fee. I guess you get a provisional patent application for utility patents. Is there such a thing for design patents?
No, but there is a way to get a design patent very fast if you're about to go to market and you don't have time to create good drawings. And that's using preliminary amendments. So what I will do when a client comes to me and says, Adam, we have a trade show on Monday, and this is Thursday, and we need to file these by tomorrow midnight, or else we're going to have public disclosure, and that means anybody can use this design and it is no longer protected. So I say, okay, well, I wish you had called me a month ago, but let me see what we can do. And if we have a CAD model or even photographs of the design, we could submit that to get protection and then quickly create drawings to replace them. And that's the attorney's special. Well, Mike would file a preliminary amendment replacing what we had just submitted and said, it was like kind of a holding place. So I will do that with renderings. I will take renderings of the product that I've created in a 3D CAD model, create the same exact views that I was going to create for the drawings. And since I'm using the CAD as the basis of the drawings, when I replace those, or if we don't do a preliminary amendment and we wait for the US patent to kick it back with an objection, we replace it with the line drawings then. I charge less for renderings. So a rendering patent might be like a $200, $300 for design patent, but the drawings could be $500 to $1,200, depending on how many drawings there are. Now, there are providers, there are a lot of patent drafting providers that aren't actually illustrators. You'll talk to them, you'll call them, and they will then send your information and your product information to India and Ecuador are the two top currently outsourcing places to do patent drawings. But once that intellectual property leaves this country, electronically or otherwise, you're actually breaking US import-export laws, but nobody has ever been enforcing this. So the way I created my small company or my micro entity is that everything is done in this country. My laptop stays in this country. So does everybody else's that works for me. We do not host any of our files on any servers that would be outside of the country. It really is tricky, and that is another way that things get knocked off, just even from getting the drawings. So protecting yourself is by keeping yourself in the bubble of your own country, which means you do pay more. I'm not the most expensive, and I'm definitely not the cheapest. But if you want a $25 drawing, yeah, India will do it, and so will Ecuador. But there'll be an American company behind it saying, hey, we're going to provide you these drawings for this inexpensive cost. LegalZoom is a great example. They'll take your patents and whatnot, and they'll outsource a ton of your drawings to wherever, and you don't know. So it's really important when you do get your patent drawings to make sure you know who's doing those drawings and where your data is being kept. Otherwise, your product can get knocked off very easily, and you'll never be able to trace where it went.
And could you say a few words about how prior art is cited with these design drawings?
That is not my department.
Oh.
That would be prior art. That's not something I typically deal with. That would be the attorneys.
I see.
Adam, I got a question. You mentioned dashed dotted lines for boundaries, and I'm not familiar with that. And do you have an example of that?
Yes, 1 second here. Bear with me. So a dashed dot line. Let me just pull up some. Let's see what I can do here. Let me see. All right, let me find a patent here that I can show you all without breaking confidentiality. Perfect. Okay. There is a company called Iron Hawk Industrial out of Ohio, and they make different curb guards. Let me see what we got here. Okay. It may not look like much. I don't know if we have the dash dot on this portion on this one. Hold on. I know these have already been published. Let's take a look at different versions.
Oh, and I have a question in the chat. It says, if you have disclaimed area and you change it, does that reboot the timing of the patent so it's now in effect longer than the original term?
Clever question. The disclaimed area doesn't matter. So you can change it as anytime you want, but there's no need to update the drawings. That's why it's disclaimed. It's saying, we don't know what's going to be here. It might be this, it might be that, but we're showing it in this fashion right now. Currently, it's this line, but it might be a squiggle line in the future if you want to change that disclaim, but it doesn't matter since you already have the protection. What you're protecting on this particular patent are the buttons on here and this one solid line in that area. Bear with me some more until I can find this. I did one with using appendixes in your design, but that's an advanced technique. I don't know if we have time to get into that one in particular. Where can I show you a dashed dot line? You know what? Let's just make one. All right, so dashed dot lines can signify the claimed boundary. So say we're going to take this and I'm just going to quickly connect the dots. Okay, and we're going to go here. Right now it's an evenly spaced dash. All right, so.
And does that mean it's disclaimed?
Yeah, it's part of the claim, but this is what a dashed dot line looks like. Now, anything on the inside, this is telling the examiner anything on the outside or on the inside of this dashed dot section is disclaimed or claimed, depending on how you type it in your spec. So Mike, if you were to say, you would have to put 2 broken line statements. This is considered a broken line. All these lines are all broken. You would put 2 broken line statements. One saying evenly spaced dash lines form no part of the claim, and dash dot lines specify to something effective. Specify that define the claim's boundary is what it is. So we can just erase all that. And we know that anything on the outside is being claimed, or we could get rid of all the shading and we can, let me back up, turn off the shade right here. And we're going to reverse it. And I'm going to say anything on the inside is claimed, anything within the boundary of the dash dot lines. That means everything else on this design, you didn't invent, you're not claiming you invented, and you're not trying to protect it. You're only trying to protect the cutouts in here. So we would add some surface shading.
Is the surface shading an important part of the claim?
Depending on where you file, it certainly is. It helps visually define what it looks like. I mean, especially if we have, here, let's say you had here we go. We have a circle. All right. Is this convex or concave? We don't know currently because we don't have any surface shading. But if we take this and we go, so you some tricky little techniques here as fast as I can. What I'm doing here is figuring out, is this going to be a convex or concave? Well, I'm going to only select. All right, it's starting to look like something, but really, I'm doing this very sloppily, so please forgive me. Okay. Now we back up. That looks kind of rounded, like a ball. the other way to do it, we can reverse that.
But Adam, I can't
Depending on
tell if
light
I'm looking
source.
at the top of the Frisbee or the Frisbee from underneath. So it could
Right.
be convex or concave.
Correct. But so what I would do is I would start going like this and making it a little spaced out more and more. And now it's become really round. You see how the distance between the lines is starting to create it, making it look like it's the top of the Frisbee now, and that it's going round instead of going inwards. I would do that on this side. That's as quickly as I could possibly draw that with the tools in my hands right now. But so surface shading is important because it will define what you're looking at. But in China, this is what we would have to submit. And there's nothing else. And since it's a Frisbee, okay, then we have that. That's a side view. Or it could be this. We don't know. But if it were this, we would have to make sure. All right, measuring. Okay, great. So now we know that there's a circle that's going to fit right there. Now that accurately reflects that. And then this would be the back side. And then the top side would be this. Same as the bottom. And now we have that protected, whatever that design is. Any questions?
Hey, Adam, I wanted just to add that if you don't get your drawings right the first time, like if you submit drawings without shading and then you get a rejection from the examiner saying, no, you need shading, then you could have a big problem because adding shading at that point could be considered adding new material, and you're screwed basically. So that's why you want to make sure you have a good draftsman working on your design patents from the very beginning.
Mike, you're absolutely correct. A good 25% of my business is fixing other people's errors. I have attorneys, patent attorneys, and different firms will come to me and say, oh, we have this provider, we have this office action. And what an office action or an advisory action is just what Michael said, that it kicked back and the examiner says something's wrong with these drawings. And, you better fix them or it's not going to get through. And that costs more money because it takes more time and it's a pain to do. Yes, so you're right, Mike. You should get it done right the first time, and you should know who your draftsman is. You can speak to your attorney, any of your patent attorneys, and you can find out or even dictate who does your drawings, because there are many patent illustrators around. There are only a few large shops, and there are many small individual patent illustrators which know what they're doing. More of those than there are the big shops, because it's too difficult to learn this on your own for many people.
Are design patents listed differently on the Google patent website?
Why don't we take a look? So I have Google Patents always. So if we want to, what do you want to look up? Frisbee. Okay. Over here, we can find out, I believe, classification, duplicate, family. They used to have a little part here that would say only search design patents or utility, but you can see with the drawings. So let's take, this is a utility clearly. All right. And then this is a design one. Nope, that's a utility as well.
If you scroll down, if any of the numbers start with the letter D, that means it's a design patent in the US.
Thank you.
So there's a flying disc toy right there. It's got a D.
There we go. This is a great example of how to show a transparent material. So you can take a look and see how the shade lines are going across and you can see through it. those little symbolic shade lines that are spaced at a different angle let the examiner and whomever else know that, hey, this material is transparent and we can see what's underneath on the inside. So they will have all of the views containing those marks. They're usually going from the bottom left to the right, like that. We've seen it all sort of like, it's the traditional shading for a window or glass or anything of the sort. What's really difficult, and I've yet to figure out, is how to show something that is semi-transparent. So it's usually opaque or transparent. Oftentimes, I will do design patents if the customer wants, they're like, you know, I might do this transparent, and I also might manufacture it opaque. So we can just use the same set of drawings in the same design patent, 7 drawings shaded like this, and then 7 drawings shaded opaque without being able to see through it. So then you have both types of materials covered and protected in the single patent. Any questions? Anybody comments? Anybody want to know anything about patent drawings? Ask away.
So are patent drawings for utility patents fundamentally different from design patent drawings?
I would say yes. First off, this is a utility patent drawing. You'll never see anything like that in a design patent drawing. All right. This is describing some type of chart. Okay. But design patent drawings specifically, like this Frisbee one up here that we were looking at, must have all of the views, a top, front, back. See this figure, the one on the bottom there is, since everything is symmetrical, you can get away with putting one view in there and saying, this is a front view, the rear view is a mirror thereof, and a left view and right view are mirrors thereof. So it's all symmetrical. So now you have a top view, you have 2 views that could be used, but I typically like to include them all no matter what. Flying disc toy. Yes, let me see here. This is the underside of that, which looks very different from that drawing, right? You see how you change the line weights and it's more solid. And since there's nothing to see through, we still have the shading in the proper areas showing that, hey, that area is transparent up in that spot. However, we're looking at the ceiling, so it doesn't really matter. It only matters when we're going here and we're looking through it. And that's why those shade lines cover more of the object lines. And the object lines are now thicker and more bold underneath there. But more importantly, does anybody have an invention right now that they're trying to protect?
I'm trying to protect something that involves a business method. So there's flow charts. I don't know if flow charts have anything to do with the kind of drawing that you do.
No, but I did hear some of your students say they have their computer science majors. So GUIs, graphical user interfaces, absolutely can be protected by a design patent, and I do it all the time. So say you Apple, for instance, you love the iPhone and all the different icons. Those icons and the way they're displayed, that's protected. So if you have another phone that starts to do that, they can sue and they can get damages. And if you've sold 1 million units, you owe them however much money if they can win it. So that's another interesting new one in the past, I would say 20 years being used, is protecting graphical user interfaces. And what you would do is create a fake screen in dotted lines, disclaimed, and saying that anything on the inside is claimed and selecting which parts are claimed. Sometimes those design patents get so broad that they only claim the separation lines or the arrows.
Is the fanciful text used for something like Coca-Cola, is that regarded as a design patent or trademark?
Trademark.
That's a trademark. Okay.
Yeah.
There's the word mark, and then there's the fancy script.
Yes, that definitely. that would be a trademark or a trade dress matter for sure. Yes. And
How do we know the difference?
Mike, I'll let him answer that one. I'm not, that's for the attorneys for the difference between trademarks and word
Well,
marks.
I mean that, yeah, I mean, if I have script that's fancy, that kind of looks like a design, but
Yeah,
you're
so-
saying it's not because
Yeah,
it's
so
spelling out a
trademarks,
word.
you can file a trademark as the plain text version. And you can file an additional trademark with a fanciful or a stylized font. And that could be two different marks. Coca-Cola and that stylized font could be one mark, and then Coca-Cola just plain text could be a different trademark. You can do both if you want extra protection. Of course, that'll double your costs though.
They don't care. They're Coca-Cola.
Yeah, but like small companies, sometimes they'll have a stylized font, and I often recommend, well, why don't you just file in plain text, and then in the future with your trademarks, you can use the stylized font or any font, and you're still protected by your plain text trademark, because you're just protecting the meaning of the word or the letters, and not any particular font.
So here's the wedge shape that I've been talking about. So this is the published design patent D661296. And you can see the dashed lines disclaiming all of the little bumps and openings and ports. So all you have left claim is this outer shape. And that was for the MacBook Air. And that's what it's unbelievable. But yeah, it says Wired put this out a long time ago, but this was such an interesting case to me, and probably to a lot of people, that, wow, it looks like a doorstop if you removed all those dashed lines. So now Apple owns the design patent on a doorstop that or that particular shape. It doesn't even have to be a computer. That's how powerful a design patent can be. The functionality of the MacBook Air does not matter whatsoever, but the look and feel of it, absolutely. And that was worth far more money than anything else.
Now, can't somebody argue that there was prior art? I mean, this can't be an original design, the wedge shape.
Nobody protected it, and the courts upheld it.
Well,
and that's why Samsung lost $500 million. They made a laptop that looked like them. And now the other thing is with design patents, and what happens in larger corporations instead of smaller individual inventors, is they build these war chests of patents. And so Samsung will say, okay, you're infringing on this patent that we have, and Apple will be like, okay, fine, but you're infringing on this one. And then they say, okay, we'll back off. Everybody can be good. And they just keep going back and forth, the internal counsels, until they're like, aha, but I got this one. And then Samsung was like, well, we got nothing to trade on that one. And so they took their money. That's behind the scenes. Yes. So I really appreciate you guys having me here. I'm all the way on the West Coast. It is still my working day, but I really enjoy talking about my work. So it's an odd niche to get into. I don't think anybody ever mentioned it to me in my entire life until someone asked me to do a patent drawing. And it's a fun thing. And honestly, I believe that if you are skilled in art and in graphic design, you could muddle your way through. And then you could potentially ask a draftsman to say, hey, can you look these over to make sure they would comply with the US Patent and Trademark Office? Or what would you do to change them? And then you could save some money and maybe have them edit it if you're looking to get your invention through on on the cheap, is the best way I can put it. Because I know every individual inventor's money is going towards other things. And sometimes the patent is an unexpected cost that you don't think about. But design patents, again, are a great way to protect your invention, even though it doesn't talk about the functionality or use of it. That's what I have to say
And,
there.
and how many years have you been doing this, Adam?
I guess since 2007.
Okay.
So let's walk that one back.
Yeah.
Yeah. 15
Cool.
years, I guess. 15,
Yeah.
16 years. Yeah.
Cool.
Mhm.
Are there any other questions for Adam? Well, then I hope you'll all join me in thanking the speaker. Thank you all for tuning in, and I hope you have a nice day.
All
Bye,
right, cheers,
everybody.
Adam.
Thank you, Adam.
Thank you.
Great.
Yeah.
Yeah,
Thank
thank
you.
you.
Quite
Bye-bye.
welcome.